Hi guys, I hope you all are doing great and your preparations for your CMA foundation exams are going very well. So today I'm here to discuss with you MCQ Bank published by your institute for Fundamentals of Business Laws and Business Communication paper number 1. Okay, so we'll quickly revise all the MCQs given over here. We have somewhere around 200 MCQs and this MCQ revision will help you to score good marks in your examination. So try to recall with me while we are discussing all the MCQs. Okay. What are the sources of law? You know it, right? Constitution of India, judicial presence, customary law, statutes and ordinance. So that's option number 2 for you. Which article in the Indian Constitution of India 1950 has provisions of introduction of a bill in Parliament of India? So try to recall the article number. Yes, that's correct. Article number 107, option number 3. Money bill is introduced in which house of parliament? Council of People Lok Sabha, Council of States Rajya Sabha, both the houses or none of the houses? Yes, money bill was introduced in Council of People Lok Sabha. Under what article of the Constitution of India 1950 is the President of India empowered to make an ordinance? So ordinance relates to article number 123. Very good. The essence of subordinance legislation can be found in which article of Indian Constitution? So see, they are asking you article based questions. You have to be very thorough with the article numbers. Article number 13. When was the Constitution of India passed by the Constituent Assembly? When was it passed? Okay, when was it passed? 26th November 1949. Became effective 26th January. When was it passed by Constituent Assembly? Which is the highest court in India? You know it very well. Yes, Supreme Court of India, option number 2. Which article of the Constitution of India have the power to entertain petitions of violation of fundamental rights? Where the fundamental rights will be entertained? Article number 226 and 32. You have to remember this one. This is very important for you people. Which is the highest civil court in a district? District level, you will have your district court as the highest civil level. Which article of Constitution of India empowers legislature to make laws? Legislature can make laws under articles number 245. Option number 4. Okay. 1 second. Yeah, that's selected. When was the Supreme Court of India established? 26 November 1949, 26th January 1950, 28th January 1950, 1st October 1937. So the correct answer is 26 January 1950. Okay. Which article of the Constitution of India stipulates law made by Supreme Court of India? Stipulates law made by Supreme Court of India. Article number 141. What is the schedule in the Indian Constitution of India for separation of subject for legislature? Subject for legislature, separation of subject for legislature is in 7th schedule. What kind of structure does the Indian Constitution have? What is the structure we have? We have a federal structure. Okay, federal structure. Okay, let me scroll a little. Yeah. Under which article can we amend the provisions of Constitution of India? We have to amend Constitution of India's provision. So which article allows it? Article 368. Okay. Which is the lowest court to approach for criminal matters? Which matters? Criminal. Judicial magistrate, option number 2. Mention the number of judges in the Supreme Court of India, including Chief Justice of India currently. That is a very important question they can ask you. That is 34 judges. Fundamental rights are mentioned under which part of Constitution? Which part of Constitution discusses? Part number 3. Okay. Municipalities are provided for authority under which part of Constitution of India? Part number 9, part number 9A, part number 3 or part number 1? Yes, that's right. Option number 2, part number 9. Under what article of Constitution of India 1950 is the governor of state empowered to make an ordinance? Again, they have repeated this question over here. Article number 245. Okay, sorry. This is governor of state empowered to make an ordinance. Governor of state. So that is article 123. That was president. Sorry. Now, what are personal laws? Laws relating to interpersonal behavior, customs, religious beliefs that have now been codified, laws that that a person makes, or laws based on opinion. Tell me what should be the correct answer. Yes, that's correct. Option number 2, customs, religious beliefs that have now been codified. Personal behavior and etc. will not come under personal laws. Now the customs have been codified, that is your personal laws. Which article of the Constitution of India deals with inconsistency between laws by Parliament and laws made by legislate of states? There, like inconsistencies are dealt with which article number? Article number 254. Correct. What is private bill? A bill introduced by a member other than minister, bill introduced by a private citizen, or bill introduced by a private company, a bill relating affairs which are private to individual. Tell me which bill is a private bill? A bill introduced by a member other than minister, option number 1. The Parliament for the Union of India, which shall consist what? President, the Council of Members, Council of States, sorry, Rajya Sabha, and the House of People, Lok Sabha, Rajya Sabha, Lok Sabha, or Legislative Assembly. Union of India, everything. President, Council of States, and the House of People, Lok Sabha. Okay. Yes, let's go ahead. Secondary or subordinate legislation cannot go beyond the ambit of the Act, or Constitution of India, the Constitution of India, or directive principles of state policy. Option number 2 is correct, ambit of Act or Constitution of India. Okay. Now, the appellate court for National Consumer Disputes Redressal Communication Tribunal is High Court, District Court, Subordinate Court, Court of Subordinate Judge Class, or Supreme Court. Option number 4 is correct, Supreme Court. Okay. The ancient courts can be divided into 6 categories based on their rank as the Gana, Kula, Sherni, Nipa, Adhikrita, Sasita. So see, you have to see the right sequence over here. Okay. The right sequence is Kula, Sherni, Gana, Adhikrita, the Sasita, and Nipa. Okay. Option number 2. Voidable contract is one which is lawful, which is invalid, or which is valid so long as it is avoided by party entitled to do so, or none of these. Yes, so your correct option is it is valid so long as the party who is entitled to do so does not avoid it. Okay, so till that time it is valid. Difference between an advertisement for sale and a proposal is no difference at all, that a proposal becomes a promise as soon as the party to whom it is made accepts it, but an advertisement does not. Every case will be viewed according to circumstances or none of these. So your option number 2 is correct, that a proposal becomes a promise as soon as the party to whom it is made accepts it, but an advertisement does not. Okay, when the proposal is accepted, they agree with it, that time you can say it becomes an offer. In a book debt, a catalog of books enlisting the price of each book and specifying the place where the particular book is available is invitation to offer, or invitation to visit the bookshop, or none of these. So a book debt catalog of books, so that is an invitation to visit the bookshop. Then you will get to know now which book is placed over where, and what is the price of that book. So invitation to visit the bookshop. A catalog of goods for company of a company for sale dash a series of offers, but only an invitation for offers is not a series of offers. They are not offering you. Catalog shows invitation of offer. You see the product, you then say, oh, I want to this, so that time you are offering. Okay, that is only invitation to offer. There are not multiple offers given in front of you. An offer does not lapse if the offerer dies before acceptance, offeree dies before the acceptance, acceptance is made by the offeree in ignorance of the death of offerer, or acceptance is made by offeree with knowledge of the death of offerer. So if you are not aware, that time only offer will not lapse. If you are aware, then offer will lapse. Option number 3 is the correct over here. A telephonic acceptance is complete when the offer is spoken into telephone, heard but not understood, heard and understood by offerer, is received, heard and understood by some person in the offerer's house. So what do you think is the correct option over here? Which one will be the correct one over here? Heard and understood by the offerer. When the offerer intended person hears, then only it is telephonic acceptance. Okay. With regard to contractual capacity of a person of unsound mind, which of the following statement is most appropriate? Unsound mind. A person of unsound mind can never enter into a contract. He can enter. A person of unsound mind can enter, but there are some restrictions. A person who is usually of unsound mind can contract when he is at the time of entering into contract of a sound mind. That is your correct option, option number 3. A person who is occasionally of unsound mind can contract although at the time of making contract is of unsound mind. This will not work, right? So option number C is 3 is the correct one. Now, while obtaining consent of the promisee, keeping silence by the promiser when he has a duty to speak about material facts amounts to consent obtained by coercion, misrepresentation, mistake, or fraud. You are keeping quiet when you have to disclose the facts. That means you're doing fraud over here. Okay? I'll scroll a little. Yeah. A threatened to commit suicide in his wife if his wife did not execute a sale deed in favor of his brother. Wife executed sale deed. So now this contract, this transaction is voidable due to coercion because coercion is applied. They said like, if you don't do this, I'll commit suicide. Suicide comes under coercion. A contract which is vitiated by undue influence is declared as which one of the following by the Indian contract? What type it is? It is a voidable contract, which is undue influence, like under the undue influence, fraud, your misrepresentation, that coercion, all these will come under your voidable contracts. Consider the following: active concealment of facts, promise made without any intention of performing it, breach of duty which gains an advantage to the person committing it, and inducing mistakes as to subject matter. Which of the above amounts to fraud? Read the options carefully and comment in the comment section which of this will amount to fraud. Okay, I'll give you 5 seconds. See, your second will not be a fraud because your intention was not there. And fourth, inducing mistakes as to subject matter. This will also not be a fraud. So option number 1, that is 1 and 2. Okay. Factors vitiating consent are: what will be affecting the consent? Tell me. Coercion, undue influence, fraud, misrepresentation, mistake. All of these, everything is going to impact your consent, right? Misrepresentation means what? Unwarranted assertion, any breach of duty without any intent to deceive, innocent mistake. So that is your option number D, option number 4. If a party stands in a fiduciary relation to the other, he cannot dominate. He can dominate the will of other. The trust should be maintained, and none of these. What do you think is the correct one? He can dominate the will of other. They're in the fiduciary relationship now, so they have a trust based relationship, authority relationship. They can influence. A person is deemed to be in a position to dominate the will of another if he holds real or apparent authority, right? Stands in a fiduciary relationship, both A and B, either A and B. So that is both. You have a fiduciary relationship also, or you have a real or apparent authority, both. Okay. Yeah, so we have discussed around 42 questions. Let's go ahead. Now, if both the parties to a contract believe in the existence of a subject which in fact does not exist, the agreement will would be unenforceable, void, voidable, or none of these. Both of them think, oh, the horse is alive, and they are discussing about sale of horse. That is a void contract. The subject matter is not in existence, right? For a valid contract, both the parties should have given their consent and the consent should be free. Both A and B and either A or B. Both should be there. Okay. When both the parties to an agreement are under a mistake as to a matter of fact essential to an agreement, the agreement is void. They are under a mistake. Both of them are under mistake, so void. Coercion, undue influence, misrepresentation, and your fraud. All this will lead to voidable. Mistake will lead to void contract. Okay, this way you can remember. Mistake, void. Others, voidable. In Indian Contract Act, the term consents ad idem means what? You should be aware about this. Parties agreeing upon the same thing in the same sense. Okay. Now, to prove undue influence, plaintiff has to prove that relations subsisting between the parties are such that the defendant was in a position to dominate the will of plaintiff. Defendant used that position to obtain an unfair advantage from the plaintiff, both A and B or none of the above. Yes, both the things are there. They were in the position to dominate and they used that position for an unfair advantage. Validity of contract is not affected by mistake of fact, mistake of Indian law, misrepresentation, fraud. other things will affect, but mistake of Indian law will not affect the validity of contract. That was your problem, right? Unlawful agreements comprise of illegal agreements, immoral agreements only, agreements opposed to public policy only, or all the agreements mentioned above. All these agreements mentioned above will be unlawful. Okay, option number 4. Now, the exceptions to the rule that an agreement in restraint of trade is void are contained in provisions of Section 27 of the Contract Act only, Section 11, 36, 54, and 55 of Partnership Act. Both the above mentioned provisions of Contract Act and Partnership Act respectively, none of the above provisions. So tell me the provisions of Section 27 of the Contract Act only. Okay, some people have a different opinion, but as per your institute, it is the provisions of Section 27 of the Contract Act only. Now, a contract to trade with an enemy is an immoral agreement, a valid agreement, an agreement opposed to public policy. So tell me, a contract to trade with an enemy, agreement opposed to public policy. You should not trade with your enemy because they are going to affect us. That is against the public policy. An agreement will be unlawful if there is no consent. Consent is not free. There is no consideration. The object is forbidden by law. We are talking about unlawful. So the object is forbidden by law. Your option number 4 will be correct over here. Okay. In a wagering agreement, both the parties win, both the parties lose, none of the parties win. One party wins, the other loses. That's correct. In the wagering agreement, one wins and the other one loses. Now, which of the following statement is correct? Void agreements are always illegal. Illegal agreements are voidable. Illegal agreements can be ratified by the parties. Illegal agreements are always void. Which of the following is correct? Illegal agreements are always void. Okay, let's go ahead. Now, which of the following is not a wagering agreement? A lottery, an agreement to buy a ticket ticket for lottery, commercial transaction, the intention of which is not to deliver the goods but only to pay the difference in price, a contract of insurance. Which of the following is not a wagering agreement? Okay, a contract of insurance is not a wagering agreement. Okay, others are wagering agreements. A wagering agreement in India is declared by the Contract Act as illegal and void, void but not illegal, voidable at the option of aggrieved party, or immoral. Tell me, void but not illegal. Correct? They are void but not illegal. Yes, let's go ahead. Which one of the following is a void agreement? Agreement without consideration, agreement in restraint of marriage, agreement in restraint of trade, or all of the above? Tell me, what do you think? Yes, all of the agreements are void agreement. Okay. There are few exceptions to agreement without consideration. That is different, but these ones basically are void agreements. An agreement which restricts a person's freedom to marry or to marry any person of his choice is against public policy and is lawful, illegal, void, or none of these. We read it in the previous one, restraint of marriage, that is void. Okay. Now, let's go ahead. An agreement of service under which an employee agrees that they will serve a particular employer for a certain duration and that he will not serve anybody else during that period is valid agreement, void agreement, illegal, or none of these. That's a valid agreement, right? No issues in this particular agreement, so it's a valid agreement. The seller agrees to supply all the goods produced by him to a certain buyer and to nobody else, and the buyer also in turns undertakes to accept the whole of quantity. This agreement is void, solus, illegal, or none of this. That is none of this. Like, no, nothing affects over here. You can go into such agreements also. They have not written valid, or else it would have been valid. M, who is a dealer in mustard oil only, agrees to sell N 500 liters of oil. This agreement is valid, void, voidable, contract, or unenforceable. That's a valid one. There's no issue in this. A and B agree that A shall pay 1,000 for which B shall afterwards deliver to an either rice or smuggled opium. In this case, the first agreement is void and second is voidable. First is voidable, second is void. First is valid, second is void. First is void and the second is valid. What do you think? Yes, that's correct. The first is valid. First, they are talking about sale of rice, either rice or smuggled opium. Rice is okay, that is valid, but smuggled opium is void. Now, A agrees to sell B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. So, valid, void for uncertainty, voidable, or illegal. So, that is void for uncertainty. We don't know no, what kind of oil it will be. A agrees to sell B my white horse for 500 or 1000. There is nothing to show which of these two prices are to be given. Valid, void, voidable, unenforceable. That's a void contract. When you're not sure about the price, that is directly a void contract. Now, agreements between a husband and wife living in friendly environment are valid contracts, void contracts, domestic agreements, or voidable contracts. So that is domestic agreements, social or domestic agreements. A promised to marry none else than Miss B and in default to pay her a sum of 1000. Subsequently, A married Miss C and Miss B sued for recovery of 1000. The contract is valid, void, or you could say voidable or unenforceable. That is a void contract. Now you can't restrain them from marriage. That is void. A promises B to pay 1000 if it rains on Monday, and B promises to A if it does not rain on Monday. This type of agreement, what is it? A wagering agreement. Depends on happening of an uncertain event. That's not under our control. Okay. P engages B to kill C and borrow 100 from D to pay B. If D is aware for the purpose of loan, the transaction is valid, void, illegal, or not enforceable. Tell me what it can be. That is an illegal agreement. You know already the purpose is not legal. Then why are you lending the loan? A leaves the firm doing a particular business in Mumbai. He agrees with the other partners of the firm not to start a similar business that of the firm in and around Mumbai for 3 years. This agreement is valid. This agreement is going to be void. Sorry. Basically, these agreements are void, like in partnership, etc. You would see that restraint of trade or the previous one we discussed over here. So that one will be covered over here, and this is a void agreement because you're restraining someone from trade. There are exceptions given, but initially this agreement will be considered as void. Okay. Now, A, while filling up the insurance application form, states his age as 25, believing it to be true. His actual age was 27. Life Insurance Corporation issued a policy in his favor, charging a lower premium than it should have charged if the actual age had been given. This is a case of misrepresentation. You are misrepresenting the data. Okay. B, having discovered a vein of ore on the estate of A, adapts means to conceal and does conceal the existence of ore from A. Owing to A's ignorance, B is enabled to buy the estate at a lower price, right? Like on estate of A has B having discovered a vein, and owing to A's ignorance, A has ignored this estate thing, like there's a ore over here. So he has ignored, is enabled to buy the estate at a lower price. He's buying at a lower price, but there is a ore below that estate, now below that land. So now you will be seeing that when there is a ore and it will extract the minerals, etc. So the value should increase. But A is not aware about it. That's why B buys it at a lower price. This contract is voidable at the option of A. If A gets to know, oh, this there is a ore below my land, below my estate. Now I want the higher value. So what he'll say, I don't want to go continue with this contract. So that is void. Okay. B, let a cabin on hire to P, a prostitute, knowing that it would be used for immoral purposes. The agreement is enforceable, valid, voidable, or void. That is a void agreement. Okay. A enters into an agreement with B, who has robbed A for 10,000 to drop prosecution against him. B, in consideration of B's returning 8,000, afterwards B refused to pay. A can get from B how much he can get, or nothing he'll get. He'll get nothing because you are agreeing with the robber. That is not right. So you are not going to get anything. That is an illegal agreement you entered in. Okay. A agrees with B to discover treasure by magic for a consideration of 500. This is a void agreement, a void contract, a valid agreement, an unforceable contract. Here he is going to discover. So that is not a contract even. That is a void agreement. Okay. X a tailor employed Y as his assistant sorry, under an agreement that Y, on termination of his employment, shall not start the business of a tailor. Now, again, this is restraint of trade, so that is going to be a void one. Okay. X promises to supply Y 1 tola of gold brought from the sun. This is a valid, illegal, void, or voidable. Tell me what it can be. So that is a void agreement. It is not also like eligible for becoming a contract. Now, A promises B to carry on a similar business as that of B if B pays him a certain amount, not to carry on the business. B pays the money, but A continues to carry on the business. Can he do anything? See, that is again restraint of trade. He can do nothing because you are restraining someone from trade. Anyone can open, right? A purchases B's business of selling neckties in Delhi. A can restrain B from doing the business of selling neckties in his life, doing any business in Delhi, doing the business of selling neckties in Delhi for a limited time. None of the above. Tell me, what can he do? Yes, what should be the answer? Yeah, for a limited period, you can tell them not to sell. Okay. A promised to marry B and none else and promised her to pay a sum of 5,000 in addition to what he gets from other party if he marries someone else. A marries C and gets 10,000 from C. B can get from A. What will B get from A? Nothing. I told you again, restraint of marriage, void contract, you will get nothing over here. Okay. Now, A promised B to obtain an employment for him in his public office. B promised to pay 2,000 to A for this. B gets a job through A but refuses to pay the money. Can he do something? He can do nothing because getting someone public job and then asking money for it is illegal. So you can't do anything. Okay. Now, sorry. A Hindu already married with living wife B enters into a marriage agreement with a widow of 30 years of age. This agreement is void because opposed to public policy. Valid can be enforced by either party. Voidable because A has obtained B's consent by exercising undue influence against her. Void because of being forbidden by law. In Indian law, you're not allowed to marry again if your first wife is alive. So that is void because being forbidden by law. Okay. Rajiv entered into a contract with Lata to marry her on a fixed date. However, before the marriage date, Rajiv went mad. With reference to Indian Contract Act, what is valid? Contract becomes void because the subject matter is not eligible anymore to marry. Okay, not a person of sound mind. So sorry. Yeah. Now. Okay. Yeah. A and B agree to deal in smuggled goods and share the profits. A refuses to give B share of profit. B can enforce or not. We are smuggling goods. We have no remedy available over here because this contract is illegal now. You're going to smuggle the goods and share the profits. No, that's not right. Right? A and B agree that law of limitation shall not apply to them. A debt becomes time barred and A refuses to pay the amount. Can B recover the amount under the terms of agreement? No, the agreement falls under section 23 and hence void. You can't recover that amount, right? Because the debts are time barred. If your time limit is gone, you can't get the money. A borrows 5,000 from B to purchase a revolver to shoot. Can B recover his loan of 5,000? Can you do it? No. Why you can't do it? Because the agreement falls under section 23 and hence void. Okay, you can't recover this. You're purchasing a revolver, that is not allowed. That's only allowed to policemen or the army and navy and everything. Now, A borrows from B 500 to bet with C. Can B recover the amount of his loan? Tell me. No. Under section 23, it's not allowed. No, the agreement is wagering agreement and falls under section 23, hence void. A paid 500 to a government servant to get him a contract of canteen. Government servant could not get the contract. Can A recover 500 paid? Can you recover that money back? No, the agreement is void. You should not give bribe, or you should not get into contracts where you will get the contract of canteen by paying 500 rupees. That is not valid, right? A person contracted to deliver a part of specific crop of potatoes. The potatoes were destroyed by blight though no default of the party. The contract is void due to frustration of contract, because the contract will not exist now. The crop is destroyed, the potatoes are destroyed right now, right? Great. One second, let me scroll a little bit. Yes. A contracts to sing for B at a concert for 1000 which were paid in advance. A is too ill to sing. Which of the following option is correct? A is bound to make compensation. A is not bound to make compensation to B for the loss of profit which would have been made if A had been able to sing, but must refund 1000 paid in advance. That is a correct option. You have to refund the advance. If some profits were going to be gained, that you are not going to refund back. Okay. Now, correct. Let's go ahead. A contractor entered into agreement with government to construct a godown and received advance payments for the same. He did not complete the work and government terminated the contract. Now, government can claim damages because he did not complete the work. Government under section 65 could recover the amount advanced to the contractor, cannot claim damages. They can definitely, and can also recover the amount advanced. So that's option 4, both A and B. Okay. Which one of the following has the correct sequence? Offer, acceptance, contract, consideration. You have to tell me now which one is correct. Offer, acceptance, consideration, and then contract. Option number 2. A telephonic acceptance is complete when the offer is, now again, heard and understood by the offer. Okay. And we have a better option. Received, heard and understood by some person in offerer's house. Okay. They have two different answers, but it should be heard and understood by the offer. Okay. That is option number 3. In your notes, it is given, like in your PDF, it is given option number 4, but I am telling you this should be option number 3. That time only offer is completed, because it should be to intended offer. In case of appropriation of goods, which are the essential requirements? Goods should conform to the description, appropriation, and quality stated in contract. Goods must be in a deliverable state. Appropriation must be by the seller with the assent of buyer, or all of the above. Tell me what it should be. That is correct, all of the above. Description should be right, must be in deliverable state, and at the assent of the buyer. Appropriation of goods means separating the goods sold from other goods, putting the quantity of goods sold in suitable receptacles, delivering the goods to carrier or other bailee for the purpose of transmission to the buyer while receiving the right of disposal. All of the above things will include in appropriation of goods. General rule of Sale of Goods Act is risk prima facie passes with ownership, possession, delivery, custody. Ownership. Nemo dat quod non habet means, tell me, none can give who does not himself possess. Okay, if you don't possess something, you can't give it to other person. Transfer of document of title to goods sold to the buyer amounts to what? Actual delivery, symbolic delivery, constructive delivery, or none of this. That is a symbolic delivery. Okay, almost 100 questions we are going to cover. Half of the questions we are almost done. Now, under Section 2(4) of Sale of Goods Act, a delivery order enabling a person to obtain delivery on payment of price is deemed as document of title, not a document of title, document enabling title of goods, not a valid document. Tell me. Deemed as a document of title, option number 1. Very good. A share certificate is document of title of goods, bill of exchange, document showing title, or instrument of transfer. So we can club it under document of title of goods. Okay. A bill of lading is, sorry, document showing title of goods. Document of title, not document showing title of goods. Bill of lading is bill of exchange, promissory note, check, or document of title of goods. Bill of exchange, a bill of lading means document of title of goods. Who is having the title now? Section 19. Yes, Section 19 of Sale of Goods Act deals with passing of property of dash goods. uncertain goods, uncertain goods, future goods, specific or uncertain goods, or contingent goods. So specific or uncertain goods. Okay. Voluntary transfer of possession from one person to another is called as delivery. Okay. Now, which of the statement is incorrect in connection with the duties of seller and buyer? Okay, it is the duty of seller to deliver the goods, not compulsorily. It is the duty of the buyer to accept and pay for them. Yes, that is there. It is not the duty of seller to deliver the goods, or it is the duty of the buyer to take delivery of goods. Tell me, which of the following is incorrect? Right, duty of seller to deliver goods, it is duty of buyer to accept the goods, it is the duty of buyer to take delivery of goods. See, first one is duty of seller to deliver goods when they are asked to, so that's why it is correct. It is not the duty of seller to deliver the goods is incorrect. Okay, not compulsorily, but basically we see that seller only will deliver the goods to you na? You are ordering something from Amazon, Amazon only has to deliver to you, you won't go and get it na? Now, delivery of goods means what? Voluntary transfer of possession, compulsory transfer of possession, exchange of goods, or voluntary transfer of ownership. Tell me what it should be. Delivery of goods means voluntary transfer of possession. For a valid contract of sale, delivery may be actual, symbolic, constructive, or all of this. It is all of this. Delivery of keys of godown where goods are kept amounts to symbolic delivery. Okay, there are dash modes of delivery. How many modes are there? 3 modes: actual, symbolic, constructive. The term unpaid seller includes agent of buyer, agent of seller, agent of carrier transport, all of the above. Agent of the seller, not buyer. Right, 1 minute, let me scroll a little. Yeah, the term unpaid seller includes buyer's agent to whom the bill of lading is endorsed, buyer's agent to whom the goods have been delivered, seller's agent to whom the bill of lading is endorsed, or seller's agent to whom the goods have been delivered. Tell me which of this is correct. Option number 3, seller's agent to whom the bill of lading is endorsed. Unpaid seller can exercise his right of lien even when property in goods has passed to buyer. Only when property in goods has not passed to buyer, either A or B or neither A or B. Even when the property in goods has passed to buyer. Option number 1. Unpaid seller can exercise his right of resale of goods. When he can exercise his right of resale of goods, even when property in goods has passed to buyer. Okay. Next, unpaid seller can exercise his right of withholding the delivery even when property in goods has been passed to buyer, only when the property has not passed to the buyer. Withholding, when you can do it? Again, even when the property in goods has been passed to buyer, it has been, possession has been passed, but you can hold it at the doorstep. Doctrine of caveat emptor is not applicable in case of sale under a patent name, in case of sale under a trade name, when the seller is guilty of fraud, where the buyer relies on the skill and judgment of seller. Tell me which should be the correct one. Where the seller is guilty of fraud. Okay, that time caveat emptor is not applicable. Property in the goods, in the Sale of Goods Act 1930 means what? Ownership of goods, correct. Okay, let's go ahead. 115 questions we have covered very nicely. We'll cover the remaining also. Okay. Now, Sale of Goods Act 1930 governs the transfer of property in movable, immovable, both movable, immovable, or all types of properties. Think over it and then only answer. Right, that's correct. Only movable properties. Very good. Now, a valid contract of sale includes an agreement to sale, does not include agreement to sale, includes hire purchase contract, or includes contract for work and labor. So that is includes an agreement to sell. Okay, option number 1 over here. Now, the undertaking contained in a promissory note to pay a certain sum of money is conditional, unconditional, maybe conditional or unconditional depending on circumstance, or none of the above. It is unconditional. You can't put conditions in promissory note. Bill of exchange contains an unconditional undertaking, unconditional offer order, conditional undertaking, or conditional order. It is unconditional order. Check is a promissory note, bill of exchange, both A and B, or none of the above. Tell me. Check is a bill of exchange. The term negotiable instrument is defined in the Negotiable Instrument Act 1881 under section 13. So sometimes they can ask you definition also. The term negotiation in section 14 of the Negotiable Instrument Act 1881 refers to transfer of a bill of exchange, promissory note, or check to any person so as to constitute the person the holder thereof, payment by a bank on a negotiable instrument after due verification of the instrument, the bargaining between the parties to a negotiable instrument, or all of the above. Tell me. The transfer of a bill of exchange, promissory note, or check to any person so as to constitute the person the holder thereof. If a minor draws, endorses, delivers, or negotiates an instrument, such instrument binds what? All the parties to instrument, including the minor, or only the minor and not other parties to instrument, all the parties to instrument except the minor, none of the above. So you see, it is except the minor, negotiable instruments. In a promissory note, the amount of money payable must be certain, may be certain, or uncertain, is usually uncertain, none of the above, must be certain, compulsorily. Okay. A check is crossed when it bears across its face an addition of the name of banker, either with or without the word specially, general, restrictive, none of the above. Specially is the correct option. Okay. Is crossed specially when a check is crossed specially when it bears across its name, non-negotiable. Okay. Sorry. Under Section 118 of the Negotiable Instruments Act 1881, it is presumed until the contrary is proved that every transfer of a negotiable instrument was made after its maturity, before its maturity, at its maturity, or none of the above, before its maturity. Who among the following cannot cross a check? Drawer, holder, banker, or foreigner. Foreigner cannot cross a check. Okay. Now, let's go ahead. Where a check is crossed generally, the banker on whom it is drawn shall not pay it otherwise than a banker, shall not pay it otherwise than to the holder, shall not pay it to a banker. Tell me, what should be the correct one? Shall not pay it otherwise than to a banker. Okay. Negotiable Instrument Act is applicable to whole of India except Jammu Kashmir state, whole of India except Jammu and Kashmir city, or none of the above. It applies to whole of India now. Negotiable Instruments Act 1881 came into force on which date? They are asking you dates also. You have to remember this. 1st March 1882. Act was has the name 1881 but was enacted or applicable, came into force on 1st March 1882. Okay. The term negotiable instrument is defined in section dash of the Negotiable Instruments Act. Tell me which section? Section number 13. Okay. Which of this is not a negotiable instrument as per the Negotiable Instrument Act? Bill of exchange, delivery note, bearer check, or share certificate. Share certificate is not a negotiable instrument. Dash is not a negotiable instrument as per customs and usage. What is not a negotiable instrument? Check is not a negotiable instrument as per customs and usage. Okay. Let me scroll a little. Yes. An instrument incomplete in one way or other is called as incoherent, ambiguous, foreign, or dishonor. Incoherent. Okay. Incomplete. A bill of exchange contains an unconditional undertaking, unconditional order, or conditional undertaking or conditional order. So that is unconditional order. Repeat of questions they are doing it. Okay. Option number 2. So they can ask you, their chances increase over here. Okay. Now, a corporation can be party to a negotiable instrument if authorized by its article of association. Option number 1. Sorry, here I'll take. The grace period for payment of a negotiable instrument other than payable on demand is how many days? 3 days is the grace period. The term a check in the electronic form is defined in the Negotiable Instruments 1881 under section 6A, 61 explanation to 61A, explanation 1A of section 6. So you are going to write explanation 1A of section 6. Right? This is important. You should not write 61A. Explanation 1A of section 6. Okay. How many parties are involved in bill of exchange? Tell me. 3 parties. Very good. A promissory note, bill of exchange, or check drawn or made in India and made payable in or drawn upon any person resident in India is treated as an inland instrument, local instrument, foreign instrument, or indigenous instrument. So that is an inland instrument. Okay. If an instrument may be construed either as a promissory note or bill of exchange, it is a valid instrument, ambiguous instrument, a returnable instrument, none of the above. Tell me, what is it? It is an ambiguous instrument. Okay, because there's a confusion now, either it is a promissory note or bill of exchange. So when you have the confusion, that is ambiguity. Okay, if the words not negotiable are used in special crossing in a check, the check is not transferable. Okay, under Section 118 of the Negotiable Instruments Act 1881, it is presumed until the contrary is proved that every transfer of a negotiable instrument was made after its maturity, before its maturity. Again, repetition of question. The chances increase. When an instrument is drawn conditionally or for a special purpose as a collateral security and not for the purpose of transferring property therein, it is called as escrow instrument. Very good. When a check is payable across the counter of a bank, it is called OTC check, open check, crossed check, or restricted check. Correct? Open check. Option number 2. Very good. Let's go ahead. A promissory note must be in writing, unconditional, signed by maker, or all of the above. It should be all of the above. In writing, unconditional, and signed by the maker. Communication that originates at a lower level and flows to a higher level is called as upward communication. Option number 1. Okay, let me scroll a little. We are on to last few questions and then we'll be done with this. Okay, now communication up among employees at the same level, that is lateral communication. Okay, in the organization structure is called lateral communication. Option number 3. Very good. Now, which of the following should be avoided in group discussions? False statements you should not use. Okay, positive body language, leadership initiative, and confidence is required. Next, which business communication uses provides a bird's eye view? Presentation will give you a bird's eye view. How many types of communication take place in an organization? There are 4 types of communication. Okay. In which business communication a speaker has to clearly speak for against a topic you're speaking. This is what you have learned in school also. Debate competitions. Debate includes face-to-face interaction with customers for closing the sale. You are directly doing it, so what it is called as personal selling. Okay, now use of coupons and samples come under which type of marketing? That comes under your sales promotion. Okay, now, what is the situation when a bad image of company is created? That means bad negative PR. Simple, fast, you can select this. Business communication helps in establishing dash in the market. What does it establish? Professionalism. Okay. Now, participants involved in the process of communication must be open-minded. You should be able to see all the points that people are presenting. Okay. Which of the following is not one of the 8 C's? Recall all the 8 C's. You will not see curiousness over there. Conscience is there, considerate is there, correctness is there, curiousness is not there. Need of proper grammar and syntax comes under which type of communication of C? Tell me. Yes, think over it again. Correctness. Okay, correct grammar, correct wording, syntax, and everything. If a message is short and to the point, the message is said to be concise, short. Okay. The way the information is described or translated into a message is called as feedback, decoding, encoding, or none of the above. You are describing, translating, encoding. Okay. Affirming comments with regard to future behavior is called as positive feedback, negative feed forward, positive feed forward, or decoding. Tell me what it should be. It is positive feed forward. Okay. Now let's go ahead. Corrective comments with regard to past behavior are called as, tell me, corrective comments with regard to past behavior are called as negative feedback. Okay, that is option number 4. Now, Interpretation and conversion of information communicated into the intelligible form so that the recipient can fully understand the true meaning of information is called as decoding. Right? We are opening up the message. What is the first step of communication process? Tell me. Encoding. Method of delivering the message is known as channel. Very good. Feedback is needed to which type of communication? One way, two way, both A and B. Two-way communication, because we are expecting some answer from the other person. No? Communication happens when a person randomly chooses some person to pass on the information which is of little interest but not important. Tell me what type of it is. Probability chain. Now, communication starts when a person tells something to a group of people and they pass the information to some more people, and this way information is passed to everyone. So you know very well this is gossip. Gossip chain. Then what we have is, which of the following is not an advantage of formal communication? Secrecy is not there. Everyone knows about it. At which stage of communicator focuses on correcting the grammar, spellings and mistakes? Tell me where they focus. Proofreading. Study of body language is called as kinesis. Then a cloud computing is availability of computer resource off demand, from demand, on demand, none of the above. On demand. Cloud computing, whenever you require, on demand. Cost incurred in interacting with customers via video call has been dash constant, reduced, increased. Tell me, is has increased because now everyone is using those ways. Providing frequently asked questions to customers result in which of the following benefits of internet communication? Support, care, professional presentation, personal touch, or none of the above? Support, care, because you're already providing them answers to the questions that may come up. Professional behavior includes behave in a dash manner, neutral, positive, negative. Positive manner. Business attire refers to dash manners, quality, clothing. Attire means your clothing. It is to interrupt people while they are speaking. Polite, desirable, rude. So it is rude to interrupt. At the end of the day, who needs to be satisfied? Customers. Writing is personal in nature. Which of the following skills is most important for professionals like editors? Oral skills, writing skills, presentation skills. Presenters, it is important for editors that they have their writing skills nice. Okay, good. In which type of letter buyer want to know the price and quality of the goods they are willing to buy? Quotation, inquiry, complaint, or your order in inquiry. How many reports are there on the basis of legality? There are two types of reports. A stage wherein member have spotted the difference in their cultures and they look upon the difference as negative is called minimization, integration, denial, or none of the above. This is none of the above. Mr. A and Mr. B belong to two distinctive cultural backgrounds. Mr. B believes that his culture is superior compared to culture of Mr. A. This phenomena is called as ethnocentrism. Okay, ethnocentrism. Now, sorry, that stage at which members learn to accept each other's culture, however they still remain devoted to their own respective cultures, that is called as adaptation. We are adapting with the other people's culture also. Let me scroll a little, almost at the end of it. Okay, recognizing the different types of cultures, similarities and difference between without being judgmental is called as what? Cultural sensitivity. You are being sensitive to other cultures, you are accepting them also. Which of the following is not an example of physical communication barrier? Telephonic disturbances, distance, background noises, and language. Tell me, language is one of the barriers of physical communication. Okay. Excessive usage of technical jargons and double meaning words. What are this type of barriers? Semantic barriers. Information overload is when listener gets inadequate information, gets too much of information. Overload happens when we have too much of information. So I hope this session was not overload for you and you were able to listen to all the 190 questions at a stretch, and it was very helpful for you. In an hour we have completed entire questions. Okay, I wish you all the best for your examinations and hope this video was very helpful for you. Thank you.